In the patent infringement litigation case of GoTV Streaming LLC versus Netflix, the Central District of California denied Netflix's attempt to compel GoTV to provide information as to the source of its litigation funding. Joining me to discuss why this ruling is important when it comes to high-stake litigation is my colleague Eric Caligiuri. We'll be talking about this case on this installment of The Briefing by Weintraub Tobin. Eric, thanks for joining us today.
Scott, great to be here.
Eric, can you give us some background on the GoTV Streaming's case and its claims against Netflix?
Sure. So GoTV Streaming, the plaintiff, filed suit against Netflix back in 2022 on 3 patents related to basically video streaming or the streaming of content over to mobile phones. As part of the litigation, Netflix sought to compel sort of who was behind the litigation. They thought that maybe GoTo Streaming was not necessarily the main actor driving the litigation. And this kind of goes back a little bit. It's something new in the last couple of years where these sort of larger patent assertion entities have been coming around, basically billion-dollar companies suing companies like Netflix over and over again through these what we'll call shell companies, where they're basically creating these smaller companies just to assert the patents, and they do it 5, 10, 15 times. So that's sort of where this comes from. And like I said, these patent assertion entities are a pretty new thing. It's been around for 20 or 30 years in a smaller form, but in the last couple of years, it's really blown up to where these are almost basically big businesses doing this full time, getting billions of dollars a year.
Yeah, those types of entities are referred to with an acronym, right? There, what is it, non-operating entity or something similar to that?
Yeah, patent assertion entity, non-operating entity.
Yeah.
Basically, it means that they don't make any product or services themselves. They simply license or assert patents.
Was GoTV, to your knowledge, is GoTV a non-operating entity, or was it a real company that was really involved in the licensing of its patents and creating product?
I'm not sure. It may have been at some point been a real company. I don't know. I didn't look into that, but I think at the moment that Netflix thought it was no longer an operating company.
Got it. Yeah, and Netflix argued when it sought to compel the disclosure of the third-party funding, Netflix argued that this information was essential to understanding the financial dynamics behind the lawsuit. Netflix contended that such funding arrangements might create conflicts of interest, influence the litigation strategy, and were critical for a comprehensive assessment of the case and ensuring a fair trial. And GoTV, of course, argued that this information was irrelevant to the patent dispute. What's your take on Netflix's position as a patent litigator? Did they have a legitimate position, or were they just trying to discover information which may sway the jury one way or the other, or the trier of fact one way or the other?
Yeah, I mean, the argument that the court basically came to was the relevance argument. But what Netflix said they really wanted it for was, as I said, if he goes back, GoTV claimed to be sort of a smaller entity, but you can make arguments to the jury that, hey, this isn't a David and Goliath type case, where David would be GoTV, but this is really Goliath versus Goliath, that there was billions of dollars of well-capitalized funding behind the litigation. And that can go into all kinds of things like arguments to the jury, possible conflicts, things like that. So that's partly why Netflix wanted it.
Yeah, I mean, to me, that would seem like a key reason, right? The litigation narrative, the story that you're going to tell to the jury. Is this a small little company whose patent is being infringed by big bad Netflix, or is this a profiteer who is in the business of suing many entities that is not a small company, that's well capitalized by some large, fund that is as well-heeled and well-financed, well, maybe not as well-heeled and well-financed as Netflix, but certainly well-heeled and well-financed. I definitely see why Netflix would want that information. But you were going to say there was a second reason.
Yeah, that's exactly right. That's sort of the main reason. I mean, that's sort of the main reason I think why Netflix, wanted it. That was, sort of underlying why they were getting at. I mean, the only other maybe sort of second reason would be just to sort of understand, who's suing them, who's behind this. To see, to say, hey, I've been sued 10 times by, by the parent corporation here, by the entity really behind this thing. And to maybe, get some information as to who's, it's nice to know who's actually suing you, to see if there's other ways around that. Go contact them so you can get a broader license, something like that.
Right. And from your article, it seemed like the fact that the agreement between the litigation funding source, because, well, let's take it a step back. Your article discussed the fact that there was an in-camera review of the various litigation funding documents, right? Do you want to maybe explain to our viewers what this in-camera review, or what an in-camera review is, and what it would necessarily involve?
Sure. So that basically means that in this place, the plaintiff, GoTV, would turn over the requested documents to the court, to the judge, and the judge would actually look at the documents and make a determination whether there was something in there that would be relevant to the litigation. If the court decided there wasn't, as they did in this case, then they would say, well, you don't have to hand this over to the defendant, Netflix, because I don't see anything in here that's going to be really relevant or goes beyond what you might already know. Go ahead.
No, continue on, please.
And as you said, sort of what it was looking for specifically in this case was, the sort of the monetary interest of the litigation funding aspect of it, to know whether there was any valuations put in the agreements that could help shed light on, presumably, I don't know if it was specifically in the case, but specifically Netflix was probably saying that this would be relevant to damages, for example, royalty rates, things like that.
Yeah, and it seemed like, at least from your article, that the fact that the litigation funding documents did not contain any patent valuation information relating to the patents that were the subject of the lawsuit, that seemed to be crucial to the court's ruling. Did that, in reading the court's ruling, did that strike you to be the case as well?
Yeah, I think exactly right. I think that was sort of, after the court did the in-camera review, that was it, because as I said before, the court ultimately denied the motion based on relevance, saying that there was nothing in there that went beyond what Netflix already had. They did already have the name of the company, but they didn't have anything more. Since there was nothing in the funding documents, litigation funding documents, that went beyond just the name. In other words, like I said before, things that might go to evaluation of the patents, royalty rates, things like that. Since none of that stuff was in the agreement, the court said there's nothing else here that you need.
Yeah. I mean, it's interesting. Like, one, I think that that's an important point to keep in mind for those that may become parties to litigation funding agreements, is not having any valuation information in the agreements or any of the documents between the parties. It seemed to sway the court here. The other thing is, like, in the research that I did about this case, it seemed that a number of other commentators thought that this was a very important case, at least with regards to high-stake patent infringement litigation. Do you share that opinion? And if so, could you explain why this case is important?
Yeah, absolutely. Like I said, this is a fairly new sort of development in the law in the last couple of years, partly driven by these, newer, bigger, really, like we're talking about, sort of Goliath corporations that are creating these shell companies. And it's something that's sort of come around in the last couple of years. So it's a fairly evolving area of the law. And there's been other cases and other courts that have looked into this in terms of how much the defendants, get to look into who's really behind these litigations. So it's definitely a very, important piece that, if you're on the plaintiff side or you're on the litigation funding side, to know, hey, look, if I don't want to get my name out there, I got to be careful what I put into these agreements, like valuations of the patents, royalty rates, things like that. If otherwise, it's possible that defendants may be able to, get all of my documents.
Yeah, and it also seemed important that that it just wasn't an easy get for a defendant to obtain these documents in discovery. That they would have to prove relevance, and it seems that the relevancy bar is somewhat higher, right? I mean, this is, why don't you explain what a a party seeking the disclosure of information and discovery has to establish with regards to relevance. And do you think that the court applied, in this case, the court applied that bar properly?
Yeah, so basically, to get discovery, you have to show relevance, which means it has to relate to a claim or defense. You have to show it's somehow related or ties into a claim or defense. I mean, here I am a little surprised. I'm not going to say the court didn't apply that properly. I was a little surprised the court denied the motion that wasn't relevant, because relevance typically is a pretty broad standard. I mean, there's lots of case law that says it's not a fishing expedition, you can't get everything. But typically courts will err on the side of relevance.
I mean, usually, right, relevance is, at least from my early days of practice as a litigator, is it likely to lead to the discovery of admissible evidence, right? That seemed, at least that's the general rule of relevance, right?
Yeah, there's different ways the courts will look at it during defining. Yes, that's one way. Definitely one standard they'll use. The other one is, it's got to be related to a claim or defense, which then would lead to, the discovery of admissible evidence. So in this case, like I said, it was a little surprising that they wouldn't be able to say that these documents would in some way, shape, or form go to some sort of claim or defense. One big point the court did also make was that GoTV Streaming, the plaintiff, did disclose the name of the company behind the litigation. I think probably the court would have made them disclose that if they hadn't done that. So they would have been given the name. The question was, did Netflix get to go any further into some of the underlying, litigation funding agreements, things like that? And the court obviously said, no, it wasn't relevant because there wasn't anything more you can get to that. And like I said, initially, my initial take was I was a little surprised by that ruling.
I guess now by that ruling, if you're the defendant and you're sued by a non-operating entity, you need to present a stronger argument as to why that information is relevant, or maybe have a narrower scope of the information that's requested and try to establish relevancy that way. Interesting. Well, let's keep an eye on this case. Obviously, it's a very interesting case, and we'll have you report back if there's some significant updates in this. But Eric, thanks for joining us. This was very interesting.
Will do. And thanks, Scott. Thanks for having me.
I'm Scott Hervey from Weintraub Tobin. Thanks for joining us on this installment of The Briefing by Weintraub Tobin. I was joined by my colleague, Eric Caligiuri. We hope you enjoyed this episode. If you're interested in more content like this, well, we've got over 100 episodes for you to choose from. Please remember to subscribe to our YouTube channel and to our podcast. And if you like this, feel free to leave us a comment. Thanks.